Your heat stopped working 3 weeks ago. You texted your landlord. You called. You emailed. You got a response that said, "We'll look into it." And then nothing. Absolute silence. And now it's been weeks, it's cold, and you're sitting in a rental that you're still paying full price for, while your landlord does absolutely nothing. Here's what most tenants do at this point. They wait. They send another polite message. They apologize for bothering the landlord. They feel like they don't have options. They feel like the landlord holds all the cards. And that feeling, that powerlessness, is not just frustrating. It's costing you. It might be costing you money you're legally entitled to keep. It might be allowing a situation to drag on that the law actually gives you real tools to fight, because here's what almost no one tells renters. There is a legal framework that exists specifically to protect you in this situation, and most tenants have no idea how to use it, or even that it exists. That's what this video is. Your checklist, your roadmap, step by step. So that the next time you're in this situation, or if you're in it right now, you know exactly what you're looking at, what your options are, and how to move. Before we get into it, I have to be upfront about something. I'm not a lawyer or legal advisor. This video is educational and informational only. Tenant law varies significantly depending on where you live, and your specific situation matters enormously. Please consult a qualified attorney or a local tenants' rights organization about your specific case. Okay, now, let's get into it. Let's start with the thing that changes everything. The thing that most renters don't know they have. It's called the implied warranty of habitability, and it is the legal foundation underneath every repair dispute in a residential lease. Here's what it means in plain language. When you rent a place to live, the law in most states doesn't require you to find a clause in your lease that says your landlord will keep the place livable. That obligation exists, automatically implied by law. From the moment you sign that lease, your landlord is promising, whether they put it in writing or not, that the home they're renting you meets basic standards of habitability: working heat, functioning plumbing, structural safety, no dangerous infestations, a working toilet. These aren't extras. They are the baseline the law requires. Why does this matter? Because it means your landlord can't hand you a lease that waives this. They can't write a clause that says, "Tenant accepts the unit as is with no obligation on the landlord to repair." In most states, that clause would be worthless, unenforceable, because the warranty of habitability is a legal obligation that sits above whatever the lease says. And here's where it gets even more powerful. If your landlord is in breach of this warranty, if they're failing to maintain your unit in habitable condition, not eliminating it necessarily, but reducing it, potentially significantly, courts across the country have held that when a landlord breaches the implied warranty of habitability, the tenant's rent obligation is reduced in proportion to how much the breach has diminished the value of the home they're living in. That is the legal foundation. Remember it, because everything else we're going to talk about builds on it. Now, the checklist starts here. Step 1, and it sounds almost too simple. Write everything down. And write it down now. The moment you realize your landlord isn't responding to a repair request, you need to start building a paper trail. Not because you're planning to sue anyone necessarily, but because if this situation escalates, and sometimes it does, that documentation is what separates tenants who have options from tenants who don't. What does that mean practically? It means sending your repair requests in writing, not just a text that can be deleted, not just a verbal conversation that can be denied later. Email is good. Certified mail, where you get confirmation that it was received, is even better. You want something that shows the date you made the request, what specifically was broken, and that your landlord was made aware. Keep a log, date and time of every communication, what was said or written, what the response was, or that there was no response. If the problem is getting worse, take photos and videos with timestamps. The more specific and dated your documentation, the stronger your position becomes if you ever need to use it. Here's something that the legal history on this shows us. One of the most important real-world cases that shaped modern tenant rights involved a woman who had hired a plumber to fix a broken toilet and deducted the cost from her rent. When her landlord tried to evict her for non-payment, she used that repair cost as her defense in court. She won in part because she could show she had done everything right. She had notified the landlord. She had given the landlord a chance to fix it. She had the receipts. The documentation is what made the defense work. Step 2, understand specifically what you're dealing with and whether it crosses the line into a habitability issue. This matters because not every repair dispute is equal. A dripping faucet is annoying. A broken heating system in winter is a habitability violation. A loose cabinet hinge is minor. Active mold, vermin, or a roof that leaks into your bedroom, those are serious. Understanding where your situation falls affects what tools you have available to you. Generally speaking, courts and housing codes tend to agree on certain basics that are required for a unit to be habitable: working heat and hot water, functioning plumbing, weatherproofing, meaning windows and doors that seal against the elements, protection from vermin or insect infestation, safe electrical systems, structural integrity, meaning the building isn't in danger of falling apart, and sanitation, working toilets, plumbing that drains properly. If what you're dealing with falls into one of those categories, you are almost certainly looking at a habitability issue. And habitability issues carry much stronger legal weight than cosmetic repairs. Look up your city and state's housing code. Most cities have specific housing codes that detail what landlords are required to maintain. These codes exist independently of your lease. And here's something important. In most jurisdictions, a landlord's violation of the housing code doesn't automatically give you a right to sue, but it does give you documentation that goes to a housing inspector. And calling a housing inspector is a powerful move we'll talk about in a moment. Step 3, give your landlord formal written notice, and mean it. A text saying, "Hey, the heat still isn't working," is not the same as a formal written notice. A formal written notice says, clearly and specifically, what the problem is when you first reported it, that the landlord has not addressed it, and that you expect it to be repaired within a specific, reasonable time frame. In many states, this written notice is a legal prerequisite before you can exercise any of your repair remedies. Send it certified mail if you can. Email with read receipts if that's not possible. Keep a copy. State the problem clearly. State the date. State the deadline. Be firm but factual. This serves two purposes. First, it creates an undeniable record that the landlord was put on notice of the problem and given a chance to fix it. Second, in many states, this notice is the legal trigger that opens the door to the remedies you actually want. Step 4. Contact your local housing authority or building inspector. This is the step most tenants skip, and it's one of the most powerful moves you have. Almost every city and county in the United States has some form of housing code and some form of enforcement mechanism: a housing inspector, a code enforcement office, a health department. These officials have authority your landlord does not want them to exercise. They can inspect the property, they can issue violations, they can require repairs, and in serious cases, they can revoke the certificate of occupancy, the document that allows the landlord to legally rent the unit at all. So let's pull this all together. Your landlord is refusing to make repairs. What do? You document everything, and you do it in writing. You identify whether your situation rises to the level of a habitability issue. You give your landlord formal written notice with a clear deadline. You contact your local housing inspector or code enforcement if the problem isn't addressed. You research the specific repair remedies available in your state repair and deduct rent abatement